my wife and I are currently watching a television series streaming on Paramount. It's called 1883. Some of you probably watched it. Don't tell me how it ends. I got 2 episodes left. But I'm going to tell you how it begins. 1883 begins. The scene opens up on a young woman who is obviously a pioneer and traveling across the Great Plains in a wagon train. And her wagon train has obviously just been attacked by marauding Indians. And there are dead people around. The wagons are burning. People are being scalped. It's a terrible situation. And we see Elsa wakes up and she sees this Indian coming for her. And she quickly pulls out a pistol and points at the Indian. The Indian points his bow and arrow at Elsa and says, "Don't do it." And Elsa says, "Well, you're going to kill me anyway." And he says, "No, I'm going to capture you and sell you." Apparently, Elsa was not happy with being captured and sold because she promptly shot the Indian and he shot her. And we see Elsa then stumbling around with an arrow sticking to her as she's walking toward the rest of the marauders, and she's firing her pistol and they're coming toward her, and the scene fades to black. And in the next scene, we see the beginning of Elsa's trip. Well, obviously we've seen the end of the story, or something near the end of the story. And now, of course, we have to see the whole story. You know, well, how did Elsa get where she was? I mean, what was her story? What put her in the place that she was in so that she could be attacked by these Indians at this time? And what brought her to this point? And so you have to watch the whole thing. You have to know Elsa's entire history to know what brought her to that particular moment in time. The reason I bring this up is because what I'm going to talk to you about today is trying a case, an ERISA case, under the de novo standard of review in federal court. And the thing that occurred to me when I told Amber that that's what I was going to speak about, she said, "Well, could you say something about personal injury?" And I said, "Well, yeah, that's personal injury case."
I don't know.
"Can you say something about family law?" And I said, "Well, yeah, ERISA, that's family law as well." And she said, "Well, she didn't know that much about ERISA." And I understood that. Not very many people do. I think, as George just told you, there weren't a lot of people. There weren't a lot of ERISA lawyers, at least people like me, who represent claimants and ERISA claims. And when I started doing this type of work 25 years ago. And so I think before I can tell you, and I promise that by the end of the day, I will tell you what you need to know about trying an ERISA case under the de novo standard of review in federal court. But I'm not going to talk about that for 50 minutes, so you're welcome. What I'm going to tell you is how we got to where we are today and why that is such a big deal. Why is it important that we can try an ERISA case under the de novo standard of review in federal court? And to understand why that is a big deal, you have to first understand the backstory. How did we get to where we are today? And so, just like in 1883, where we went back to the beginning of Elsa's story to learn how she got to the point in time that we know she will eventually arrive at, I'm going to take you back to the 1950s and the 1960s, when in this country, this is an economic boom, post-World War II. There's lots of companies that are having competition to get employees. They need employees to work for them. And so they're starting some new programs to convince people to come and work for them. They're offering them these newfangled things called pensions and benefits. You know, it used to be, historically, you went to work for someone, well, they might pay you. But that's it, they just paid you. But at post-World War II, it became more important for companies, if they wanted to be competitive, if they wanted to get the best employees, they had to offer them more than just a simple salary that anyone would offer them. They would offer them extra things, you know, retirement benefits, and things like health insurance, things like life insurance. Well, as you can imagine, once these things started, human nature being what it is, a lot of these plans began to become abused. It was very common, for example, for a company to set up a pension plan, and the people who set up the pension plan would get their employees to contribute to this pension plan. But then when in the fine print of the pension plan, there might be clauses like, in order to be vested in the pension plan and to actually get your pension when the time came, you know, you had to be, you know, born on a full moon on a leap year, you know, it would be criteria that perfectly fit the founder of the plan, but maybe not anyone else. So what happened to everyone else's money? They got it contributed to the pension plan. Well, it was forfeit because they didn't invest. It was kind of a wild west as far as these pension plans. Also would have been comfortable. And so this situation caught the attention of Congress. In 1974, Congress decided that something needed to be done. And Congress passed sweeping legislation called the Employee Retirement Income Security Act, or we know it by its acronym, ERISA. And this was such sweeping legislation that virtually everyone in this room, whether you know it or not, has probably been impacted by an ERISA plan. If you get employee benefits from work, if you get your medical insurance, get life insurance, get disability insurance, you're a participant in an ERISA plan. Probably very few people in here have pensions. We don't really do that much anymore anywhere, but if you do, that's an ERISA plan. And Congress passed the ERISA statute to establish a framework for handling these claims so that people get treated fairly and that people didn't get cheated. And it was a good thing. It was public interest legislation that was really designed to help everyone. And then Congress wiped its hands of the matter and said, we've done our job, pat itself on the back, and Congress goes off to do something else. And from that point on, we have this new sweeping legislation, ERISA, which covers not only retirement and pension matters, but it also covered any type, just about, of employee benefit plan. So your medical insurance, your life insurance, your disability insurance. There's other types of plans. If your employer sets up a plan and pays for it and gives you benefits as an employee benefit, it is probably an ERISA plan. And so those types of claims are called ERISA welfare benefit claims, as opposed to ERISA pension benefit claims. So we have this new framework for these ERISA claims, and we're going to treat everyone fairly. Well, how do we do that? How do we treat people fairly? What do we do when you have a dispute? Well, the Supreme Court in, what was it, 1981, in the Pilot Life case, decides versus Doe, decides that what we need to do is we need a federal common law in order to decide these ERISA claims. And they say, okay, well, we need a federal common law to decide ERISA claims. Where are we going to look for federal common law? ERISA is a new thing. There is no such thing as ERISA prior to a few years ago. It's an entirely statutory framework. Common law, as opposed to statutory law, common law is, what do we do in the past? What did they do in old England? If someone committed a tort against you, why do you call it a tort? Well, it's called a tort because that's what it was called, a common law. And it's why is this a chattel? Well, because we're talking about archaic English law, that was its term, and that's where common law comes from. But we don't really have any common law that we can apply to an entirely statutory framework. So we had to come up with one. We had to decide what to do. So the Supreme Court put on its thinking caps and they said, okay, well, where are we going to look to come up with a federal common law for ERISA claims? So, well, we can look to trust law because ERISA deals with trust issues. They have fiduciaries and they have all sorts of language used in trusts. So we could look at a federal common law of trusts. So, well, but ERISA also has lots of insurance policies and plans that look like insurance policies. And of course, everyone in here knows that an insurance policy is a contract. So we can look at contract law. We can look at the federal common law of contracts to come up with a body of law to decide ERISA claims. And the problem is that if you were talking about an ERISA pension benefit claims, trust law was more well suited for governing those claims. If you were talking about an ERISA welfare benefit claim, contract law was better suited to decide those claims. Well, obviously, the obvious answer, to me would be, okay, you use trust law for pension benefit claims and contract law for welfare benefit claims. But apparently that never occurred to the Supreme Court. They thought they needed to choose one or the other, and they chose contract law. I'm sorry, trust law. So the federal common law of trusts would be the framework that we're going to handle disputes over ERISA claims. And this became a real problem for people who had a dispute with their employer-provided insurance company. I have a problem with my life insurance because You know, someone died and they won't pay it. Or my disability insurance, I became disabled, won't pay it. Or my health insurance, I need to have this medical procedure. They won't pay for it. They should pay for it, but they won't. And trust law is not very well suited for deciding these contract issues. So the Supreme Court got busy again and decided that, well, we're going to have to figure out how to use trust law to decide contract claims. And in 1989, Firestone Tire and Rubber Company versus Bruce, the U.S. Supreme Court said that, okay, we're going to use trust law to decide these ERISA contract claims, but there's going to be some rules. You know, we're going to decide these claims de novo, meaning we're going to decide whether or not the ERISA plan made the right decision when it denied a claim. If, going back to trust law, if these ERISA plans have the discretion to make those determinations. And if they don't, and if they do, unless they have discretionary authority to make these determinations. If they were to get delegated discretionary authority to make these determinations, then the ERISA plan would have discretionary authority to make these claims determinations. And this was a hugely important decision because imagine for a moment that you're dealing with an insurance company, a claim under an insurance, could be any type of insurance claim. Hail's on your roof, insurance company doesn't want to buy you a new roof. Someone rear ends you, insurance company doesn't want to pay. We all know that in the insurance context, we have all sorts of protections. We have an insurance company who's my insurance company handling my claim. They have a duty of good faith and fair dealing toward me. I've got the Texas Insurance Code, Chapter 541 and Chapter 542, the Texas Insurance Code, which establishes guidelines that these insurance companies have to follow when deciding my claims. But under trust law, none of those things exist. And since, of course, federal law under the supremacy clause supersedes state law, if you were an ERISA plan, you could be an insurance company just handling an insurance claim. And if you had a lawful delegation of discretionary authority, you had the discretion whether to pay that claim or not. Now think about that for a moment. What a great position would it be if you're an insurance company and you get all the premiums in, and then you can use your discretion as to whether or not you're going to pay the claims going out. And so after the Firestone case, that's the situation that the Supreme Court left us with, but only for those very, very few select plans that have discretionary authority. Well, of course, as you can imagine, what happened next, within about 18 months, virtually every ERISA plan had amended its documents and given themselves discretionary authority. So we're seeing a situation in the country where these were basically insurance companies are giving themselves sweeping authority, discretion to decide claims that are submitted. And some companies realized this was a real money-making venture. And there was a newly formed disability insurance company that was formed when Provident and Paul Revere Life Insurance Companies merged into a company called Unum Life Insurance Company of America. And Unum realized that they could make a bunch of money if they could get a lot of these insurance policies and turn them into ERISA plans and give themselves discretionary authority to decide claims that are submitted. And so what Unum began to do is snatch up individual disability plans from around the country. Before the Firestone Tire and Rubber decision was handed down by the Supreme Court, there were over 500 insurance companies in the United States that wrote ERISA disability insurance policies. And now there are about 15. Because what happened is that an arms race ensued, started by Unum, but a couple of the other big ones, MetLife, Aetna, Cigna, quickly jumped on the bandwagon and started approaching these smaller insurance companies and say, hey, you guys got some disability plans, don't you? And the smaller insurance companies said, yeah, we do. We hate them. We just lose lots of money. And they said, well, we'd like to buy them from you. The small insurance company says, great, yeah, we feel like we need to provide this disability insurance if we're going to be a full, if we're going to be a full service carrier, but, we hate losing money on these things. If you want to take them over for us, more power to it. And so Unum and these other companies began to sweep up these individual plans. They would ensure that they were ERISA plans, convert them to ERISA plans if they weren't, give themselves discretionary authority, and then they began to go wild, just denying claims. I got my start about 25 years ago with a Unum disability claim. I'm a board certified personal injury trial lawyer. Have been for 26 years. How does a personal injury trial lawyer end up handling ERISA claims? Well, guy comes in, he's got an insurance claim, he tells me about the insurance claim. It's hard for me to believe that the insurance company would treat him the way that it did, until I get into the particulars and realize he didn't really have insurance, he had an ERISA plan. And that's why Unum did what it did to him. Over my career, I've handled quadriplegics that were denied disability by Unum. Unum's policy was to deny every claim. Unum famously denied surgeons who went blind. I had my own quadriplegic. You almost can't come up with a category of claim that would be so outrageous that Unum wouldn't deny the claim. And they did it because they had the discretion to do so. And it takes very little to protect your discretionary authority if you have that discretion. And so, as you can imagine, the system got terribly abused, and ERISA got a terrible reputation. There's a lawyer I know in Dallas, he says ERISA is an acronym for every rotten idea since Adam. It's just terrible because the bad things that these companies would do to people, and the unfair way that they treated their claimants. And they could get away with it because they had discretionary authority. In 1991, the Fifth Circuit Court of Appeals was interpreting the Firestone case and trying to say, oh, okay, well, what do we do if you have a case that they don't have an express delegation of discretionary authority? And the Fifth Circuit said, well, what we're going to do in those cases is the plan won't have the discretion to interpret the policy, but they will always have the discretion to decide claims. Yeah, that's really where the money is anyway. If you have the discretion to decide what claims you're going to pay, then you're basically just printing money for yourself. If you're an insurance company, you take the premiums in, you exercise your discretion on what claims you're going to pay out. And so it's a Pierre case versus someone or another. Connecticut General Life, 1991, the Fifth Circuit says that's how we're going to handle ERISA claims in the Fifth Circuit. And since 1991, that would be the law in the Fifth Circuit. If you had an ERISA claim, your claim was at the discretion and at the mercy of the insurer. This was not as big a problem in health insurance claims. It was a problem, but not a huge problem. I've handled a few health insurance claims. Not as big a problem in the life insurance case. It's kind of really, even exercising your discretion, sometimes it's hard to deny a life insurance claim when someone's dead. And you can't really get away with exercising your discretion to say that they're not. There's other things that you can do, but it wasn't a huge problem. It was an enormous problem in disability claims. That's where the money was, because those claims, it generally relied on the doctor's opinion on whether someone was disabled or not. And the insurance company, who didn't want to pay the claim, would just hire their own doctor, who would invariably say, no, I don't think that person's disabled. Insurance company exercises its discretion to credit its doctor's opinion over your doctor's opinion. The claim is denied. The problem was so prevalent that a movement started across several states to outlaw discretionary clauses. There were some people who rightly pointed out that a discretionary clause in an insurance policy makes an insurance policy illusory. If you have a policy that says it's going to do something, if you meet certain criteria and then you meet those criteria and they don't do that thing, they don't pay your claim, well, then you really don't have insurance. You just had the illusion of having insurance. You thought you had insurance. You thought you were protected until you actually had to make a claim, and then you found out you weren't protected because your insurance company, since it was a risk plan, had the discretion not to pay your claim. And so it was a movement started by the National Board of Insurance Commissioners to outlaw discretionary policies in insurance and discretionary clauses in insurance policies. And several states began to look at this and pass rules and laws outlawing discretionary clauses. As of today, there are 26 states in the United States, including Texas, in which discretionary clauses are illegal. That means there's 24, though, that they're still legal. And these types of abusive practices still go on in the 24. But this movement started around the year 2000, and eventually it reached Texas. And in 2009, I was sitting in my office and I got a call from a lawyer in Dallas, a disability lawyer that I know. And he said that the Texas Department of Insurance was having a stakeholders meeting. He had submitted a proposal that the Texas Department of Insurance adopt this model rule outlawing discretionary clauses. And TDI called a stakeholders meeting. And he couldn't go down to meet the stakeholders meeting. He wanted to know if I could go down there and cover it for him. I said, yeah, sure, I'll do that. So I went down to TDI to this stakeholders meeting. And I walk into a room and we have the TDI people there, Texas Department of Insurance. We have representatives from I think they call themselves the Consumers Insurance Council. It was like an ombudsman for consumers of insurance. There are executives from about 35 insurance companies that were there, and there was me. And when we start the meeting, and they're required by law to have one of these stakeholder meetings, anytime there's proposed regulation, the TDI is going to adopt. And the TDI reps reads, okay, we have this proposal to adopt this model rule outlawing these discretionary clauses. And you had all these insurance guys looking around, well, what's a discretionary clause? I mean, if you did not handle ERISA, you didn't know what a discretionary clause was because it wasn't used in insurance except for ERISA insurance. And these guys from all these companies, State Farm, USAA, Farmers, all the people that you know, all the companies that you know, they were there because there was some rule that was going to change, going to affect insurance companies. They didn't even know what the discretionary clauses were. They didn't use them. They weren't one of the 15 that actually wrote these long-term disability policies and sold them as ERISA plans. And so, and the TDI guys really didn't know. They didn't have any experience. I was the only guy in the room that had any experience with discretionary clauses. And so I kind of took over meeting. I got to tell all these insurance executives about what discretionary clauses are, what they do, how nefarious they are. A discretionary clause gives an insurance company who has one the right to interpret ambiguities in its own contract. And that's huge because in contract law, and it applies to insurance, there's a very common principle that most of us are familiar with, that if you draft an ambiguous term in the contract, that ambiguity is construed against whoever drafted the contract. And, you know, so we don't want people to draft ambiguous contracts. We don't want people to draft ambiguous insurance policies. We want your insurance policy to be clear. You have to be able to read your insurance policy and know what's covered. You shouldn't have to read your insurance policy and say, oh yeah, I have no idea what this means. If it's ambiguous, that ambiguity is construed against the insurance company and in favor of coverage, unless you have a discretionary clause. If you have a discretionary clause and discretionary authority, you can interpret those ambiguities yourself. So what have we just done now? We've created an incentive to draft your insurance policy to be as ambiguous as possible. Because if it's determined to be ambiguous, you get to interpret the insurance company, you get to interpret those ambiguities. And most of you, believe it or not, most of those insurance executives even found that to be offensive because it wasn't something that they normally did and it wasn't something that they were familiar with. Well, the office, I'm butchering the name, Office of Public, Insurance Counsel, the Ombudsman group took up this cause and decided that this was a rule that was worth passing. And they got on board pushing it And we had hearings in front of TDI. I went down and testified. I did 2 presentations. I did a presentation on doctrine of conflict pro florentum, which is what I was just talking about, how ambiguities in contracts are construed against the entity that drafted the contract. And I did case examples. I told them stories. I said, look, let me tell you some stories. Let me tell you about my quadriplegic that was denied by you. Let me tell you about the guy that I was representing that the insurance company said he was fine. And while his appeal was pending, he died of his disabilities. And I could tell them those stories. And we got all the ERISA lawyers we could get from across the street. The state come down and testify. TDI adopted the rule and outlawed discretionary clauses in insurance policies to be delivered in Texas. And then lo and behold, the following year, 2011, the Texas legislature picked up that TDI rule and codified it unanimously, by the way, and passed a law stating that these discretionary clauses are now illegal in the state of Texas. It's the last progressive thing that the Texas legislature has ever done, but I was grateful for it. Of course, we still had the Pierre case. You remember in the Fifth Circuit, even if you don't have a discretionary clause, in the Fifth Circuit, you still always had discretion for making claim determinations. And that continued to be the law even after the Texas legislature acted until 2018, when the Fifth Circuit Court of Appeals and the Ariana M. versus Humana case revisited this issue, revisited Pierre. And the Fifth Circuit looked around the country and noticed that all the other circuits that had decided that issue had determined that if you don't have a discretionary clause, it's a pure de novo review. You don't get a discretionary review. In other words, if someone challenges your determination, you can't win simply by showing that you had something that you could hold your hat on. You had to prove it was right. If you wrongly denied a claim, under de novo review, the person whose claim was wrongly denied, they could go to federal court and they could get the judge to give them a new determination. And when the Ariana case came down, it was a watershed event, because what it meant is that at least in Texas, in the Fifth Circuit generally, but of the states in the Fifth Circuit, the only state that had outlawed discretionary clauses is Texas. So in Texas cases in the Fifth Circuit, if you've got an ERISA claim and you're wrongly denied, you have the right to go to court and prove you were wrongly denied, and you can win your case. You're not fighting against this unbridled discretion. It was a huge moment. So after 30 years, we circled back to a post-Ariana world, and we've now come to the point of you can actually go try an ERISA case under the de novo standard review in federal court. It's important that I think everyone in this room know what ERISA is, know how we got to where we are now, because it affects it affects things that we might not even think. I was talking with Amber before coming here today. She said, well, can you say something about family law? I said, well, of course. ERISA pertains to family law. How many of you in here practice family law? In family law area? So here's an easy one. Boy meets girl, boy falls in love with girl, boy and girl get married, and one or the other buys an insurance policy. They cover their beloved spouse. So if anything ever happens to them, their spouse will be taken care of. They've got this insurance. And a couple of years go by, boy will fall out of love, maybe boy meets someone else, girl meets someone else, whatever the case may be, they get divorced. But of course, people being what they are, irresponsible, they never get around to changing the beneficiary designation on their life insurance policy. Time goes by, let's say the divorce is final, boy is running out of court, he's delighted, his marriage is over, he's dancing in the street, he gets hit by a bus. And so who gets the insurance proceeds? Well, under the family code in the state of Texas, that divorce basically erased the beneficiary designation. It no longer applies because we realize that people are irresponsible and they're not going to do what they're supposed to do. They're not going to go change their beneficiary designations. They're not going to remember to do it. And that they probably did not intend for their ex to continue to have the insurance proceeds from their life insurance policy after their divorce. Family code, simple matter. Except, what happens if the insurance policy was not just the one that you went down and purchased? What if it was the insurance you had from work? Many of us have insurance policies that cover us through work, life insurance. We designate our beneficiary. Most of us designate our spouse as our beneficiary. And we tend to forget about those policies because we don't pay premiums on them. We just get them as part of our employee benefits. We don't think about them. And after our divorce, as time goes on, it never occurs to us that we might need to go change our beneficiary designation. We might get remarried. We might have children. We might have a new spouse that we want to take care of, our children that we need to take care of. And yet we have an old policy that we got through work, makes it an ERISA plan, and the beneficiary that you may have designated 15 years ago was your ex-spouse, and you hate their guts. And the last thing you would ever want if something happened to you was for that lying, cheating ex-spouse to get the insurance proceeds. But that's exactly what happens if it's an ERISA plan versus a life insurance policy. That's traditional private life insurance policy, because ERISA law is federal law, supremacy clause, federal law trumps state law, and since the family code provision, which would have erased your beneficiary designation, was wiped out by your divorce, your original designation still stays in place. And so, and I can tell you, the case books are littered with those cases. Because what happens is, when someone comes to see you and you're talking about them about getting a divorce, and you might not specifically remind them, you might tell them, hey, make sure you change your beneficiary designation, but maybe you don't, because it's not particularly important. Texas law is going to wipe out that beneficiary designation anyway, as soon as your divorce is final. And so if you forget to tell them that, or you don't tell them that, or maybe you don't know to tell them that, it's probably not going to make that much difference. Unless it's that situation that I described. It's the insurance from work. And most people have some sort of life insurance from work. And in that circumstance, someone might be a little upset that no one told them, their lawyer that they paid lots of money to, didn't bother to tell them that they needed to change this, or else that lying, cheating ex-spouse is going to get the money, down the road. And so you need to know. You need to know whether that person is covered by an ERISA plan and why things are different in the world of ERISA than they are in the world of insurance. So we've now circled back. That was my family law.
Thank you.
Digression. We've now circled back to your claim. You represent someone, or it's your own claim. You filed your claim, you've been denied, been wrongly denied, you're fighting your battle, and you can go to federal court and challenge the denial, the wrongful denial. Now, I keep saying federal court. Why is federal court? Well, there's, as you may or may not know, a lot of us practice in state courts. So the state district court is a court of general jurisdiction. Virtually anything can be brought in state district court. And by extension, if you've got the right statutes in place in county court at law. If you're here in Travis County, you can bring virtually any case you want in Travis County Court at Law. I've tried ERISA cases in Travis County Court at Law. You can do that. If the other side doesn't take you to federal court, you can try them there if you want to. And, the court has the jurisdiction here. But federal district courts aren't like that. Federal district courts are courts of limited jurisdiction. Federal district courts, you have to have a special ticket to get to a federal district court. The way you get to a federal district court, there's one of two ways. Diversity jurisdiction. You've got a claim between diverse parties, citizens of different states. And it could be, you know, if you're suing an insurance company, well, the insurance company is probably not a citizen of the state of Texas, and you probably are a citizen of the state of Texas. So you've got that, citizens of different states, at least $75,000 at issue. You don't file a $10,000 diversity case in federal district court. Got to have at least $75,000 at issue. That's one way to get to federal district court. The other way is a federal question jurisdiction. Does your case involve a question of federal law? Well, ERISA is federal law. So every ERISA case, your $10,000 ERISA case, your $2,000 ERISA case, doesn't matter what size it is, every ERISA case has federal question jurisdiction that can be filed in federal court. And with rare exceptions, that's where you will be. If you file it in state court, the ERISA plan will almost invariably remove you to federal court because they think that you don't want to be there. You know, they think no one wants to go to federal court. And so you obviously file the case in state court, so they're going to take you to federal court. And so virtually all ERISA cases are tried in federal court. The wonderful thing is when you try these cases under a de novo standard of review is from a purely philosophical standpoint, you're trying to prove that you were right and deserved to win your case. And you would think that that should just go without saying. Well, of course, that's what you're trying to prove. I'm trying to prove that I'm right. If I'm right, I should win. That's why I go to court. You know, if someone wronged me, I go and I prove that I was wrong, I should win. And that for the last 30 years, that hadn't been the case in ERISA, in the world of ERISA. If the insurance company had the discretion to deny your claim, you had to prove the insurance company abused its discretion, which meant it had no substantial evidence on which it could have relied. Very difficult standard to satisfy. But now, under de novo, all you got to do is prove that you're right, that you should have won your case. And that's a remarkable thing. I tried the first de novo, pure de novo ERISA case in the state of Texas in 2019. It was shortly after the Ariana case came out. So the Fifth Circuit changes the law and overrules the Pierre decision. And we now have pure de novo standard of review in the state of Texas. And I had a case, Pike versus Hartford Life, that went to trial in the Eastern District, Federal District Court for the Eastern District of Texas. And I tell you, it was hilarious. And the reason is that this was a case that had been developed at the claim stage and in the early litigation stage. It had been developed under the Pierre standard. And so Hartford thought it could do whatever it wanted to. If it needed some evidence in order to support a denial, well, let's send poor Miss Pike to an IME doctor. And you know, IME stands for independent medical examination. It's not independent. You know, they made Miss Pike drive from one side of Dallas to the other side of Fort Worth to see their special doctor to do her individual examination. Let me tell you a little bit about Miss Pike's case. She was a biologist who was clearly disabled, had been on disability with Hartford for several years. And Hartford decided that they wanted to try to term out her case. They wanted to offer her a lump sum to settle her case because they determined that she was going to be disabled to the maximum duration of benefits from the disability plan. And so they made her an offer. Well, it wasn't a terrible offer. It was a couple $100,000. She said no. She knew she could never return to work. She knew she would, and that was less money that she would receive if she just received her benefits. And so she turned them down. So Hartford's, okay, waited a couple of years, looked at it again. And I got Hartford's case notes so I could follow their thought process. Hartford considered again, a couple of years later, we'd like to term out this claim. And we offer a lump sum settlement. See the notes. Well, she's turned that down before. Since she's turned it down before, she'll probably turn it down again. So they didn't offer a lump sum the second time around. They sent her to an IME. And the IME was rife with errors and mistakes. Didn't matter. It was a doctor. That's all Hartford needed. They relied on the IME to deny her case. Had two medical reviews of the IME. Both of them supported the IME for some strange reason. and also doctors that Hartford chose, and they denied her claim entirely. They were going to force the issue and force her off. That all occurred when Hartford thought it was protected by discretionary review. It sent her to a doctor that it was reasonably certain it would get a favorable opinion from, and practically knew what the doctor would say. It didn't matter that the doctor had made all sorts of mistakes because they thought they had discretion. They lost discretion before that case went to trial. And so Hartford has to go to trial and explain to the federal district judge not why they abused their discretion, but why their decision was correct, and they couldn't do it. And it was just a total disaster for them. And they lost the case. It happened again. I don't know if it was the second case. It's the second reported case. The federal district case, the court cases are not all reported in the federal reporters. Some of them just have like a Westlaw citation or a Lexis citation. But there are some cases that if West Publishing thinks are particularly important cases or monumental cases, they'll actually publish the cases in the FSUM. And you get to be in the fancy law books that you see behind the lawyers who are in the TV commercials. And so there was a case out of the Southern District of Texas that I tried in 2020, Batchelor versus Life Insurance Company of North America. Same circumstance. My client, Barry Batchelor, terrible series, had a petroleum engineer, been disabled for several years, and terrible chronic illnesses. Before he got sick, he weighed 169 pounds. By the time Lina denied his claim, he weighed 119 pounds. His insurance company, in order to support the denial, made him drive from Houston to Dallas for an IME, because apparently they couldn't find any doctors in Houston who could do a medical examination, to see their special doctor. Their special doctor, among other things, thought that Mr. Batchelor was capable of lifting and pulling 250 pounds. He weighed 119 pounds. And I just did the physics, you know. It was clearly, it was hilarious. It was, you would just look at the decision, and if it weren't so monumental for Mr. Batchelor, it would just kind of make you laugh because it was so ridiculous. Yet that's what they relied on to deny his claim. Oh, also, they had to look and determine whether there are other jobs that he could do. And so they did what's called a transferable skills analysis. They did the research and determined that, I mean, he made a very high amount of money before he got sick. And they said, there's no jobs this man can do. There's no jobs in the state of Texas this man can do and earn an appropriate wage based on what he was earning before. Well, his claim was approved. Then when they decided it was time to deny the claim, even though that was their own people who said that, they got someone else from the cubicle next door to say the exact opposite. Oh no, this man, he's capable of doing all these different jobs. That's the evidence they relied on to deny his claim. They thought they were protected by discretionary authority. They lost that discretionary authority when the Fifth Circuit handed down the Ariana opinion. And then I got to be the lucky lawyer to try that case under a de novo standard of review in federal court when the claim had been prepared by a company that thought it had discretionary authority. The standard of review in those cases, I may have won those cases, but I won both those cases. I guess I'll have to let you know that. But I may have won those cases under the discretionary standard, but probably what would have happened if we had still been under discretionary standard of review is probably those cases would have settled. And they would have settled for a fraction of the amount that we ultimately won at trial, because I would have had to sit down with my client and be very frank with them and tell them that I think you have a good case. I believe in your case. I think you have a strong case. I'm happy to go try your case. And you should know this. All they have to do to win, they win by default. The insurance company wins by default unless we can show they so messed up your claim that no reasonable person could have come out with the decision that they came up with. And that's very difficult to show. And for some judges, it's impossible to show. They just receive discretionary authority, and that would end the case right there. So what would have been more likely to happen in those circumstances, that those cases would have settled, costing the clients hundreds of thousands of dollars ultimately, because they would have accepted a settlement for far less. than that case was worth, when instead they now had the opportunity to go to trial, try their case, prove that they deserved to recover and win their case. And that's all because we could try those cases under the de novo standard of review as opposed to a discretionary standard of review. Okay, we're now back full circle. I still don't know what happens to Elsa, but don't tell me. I know some people in here know. My wife and I plan on finishing the series this weekend. We have 2 to go. I want to hear it. You know, but I can tell you on the ERISA context what it means. It's very simple. Instead of trying your case under Rule 56, which is summary judgments, instead of going and filing cross motions for summary judgment and the judge decides your case, you trial your case under what's called Rule 52A, which is a bench trial. You don't get a jury, but you do get a trial to the bench, a bench trial where you can file your proposed findings of fact and conclusions of law and prove to the court that your client deserved to win their case because they met all the criteria under the policy. And that's all I got. You now know how to try a case under the de novo standard of review in federal court. Anyone have any questions?
Do you see any differences depending on which district you bring the case in? Do you have any discretion on where you bring the case?
Typically, you bring your case in the federal district that your client lived in. So in other words, if I have represented someone from Austin, I bring it in the Western District. And it's, I am in all 4 federal districts. So I try cases in North, South, East, and West. But you typically bring it in the district. It's important. In ERISA, this is different than state law. Your venue lies in the district, not in your division. So what does that mean? That means if you have a case out of San Antonio, well, I can bring that case in Austin because Austin's in the Western District. If it's not an ERISA case, if it's a state law case, and I represent someone in San Antonio, I probably have to bring that case in San Antonio under Henry Volkswagen, the circuit opinion that they can allow for an inter-district venue transfer if the other side wants to be in San Antonio. But as far as the difference goes, no. There's so many federal judges out there, we don't know who we're going to get. I know if I get filed in Austin, I'm going to get Judge Pippen or I'm going to get Judge April. And for some reason, about 3/4 of my cases go to Judge April. It used to be I had more cases that go to Judge Sparks, but not since he took senior status. I don't get to see Judge Sparks anymore. I actually like Judge Sparks. I miss Judge Sparks, but most people were scared of just Judge Sparks. But I really like him, but I don't get to see him anymore. But like in Houston or Dallas, it could be 1 of 15 judges. You never know who you get.
Well, I asked because I do patent law, and so there's a lot of form shopping people.
Sure.
People filing in Waco.
Yeah.
Before Judge Albright, and so those cases are
Right. So like those cases, they're always trying to get it out in East Texas. And so a lot of those cases, if you got a case in Dallas, a lot of people don't realize the Eastern District of Texas goes all the way down to Highway 620 in Dallas. So you try to find a way to get a foot over the line, and that puts you out of the Northern District of Texas and into the Eastern District of Texas. And now you can go file out in the Marshall Division. And that's why we got it in Volkswagen, because you had all these Dallas cases, they were filing them in Marshall because they thought they would get favorable treatment out there. You do that in ERISA, but you really can't do it in non-ERISA. But I don't like going to Marshall. I've been there. And I just file, I just file where my client lives usually. Anything else?
Regarding Ariana, the change in precedent, sounds like that's a lot worse for insurance companies now. So I'm wondering what they're going to do to try and avoid this de novo standard. And have you seen the introduction of any choice of law clauses or even something with venue to attempt to get out of that de novo standard?
Yes, yeah. There's a valid choice of law clause will generally be honored. And I do see, but I only see them in about 10 to 15% of the policies. You see them sometimes a lot more often in self-funded plans, but in insurance policies, only about 10 to 15%. And the reason is all states jealously guard their ability to regulate insurance companies. And if you're trying to get out from under the umbrella of the Texas Department of Insurance by putting a choice of law clause to try to make the law more favorable under your particular circumstances, then there's a very good chance the TDI is going to come down on you and going to take away your ability to sell that insurance in the state of Texas. And so you do see it sometimes, but it's not hugely prevalent.
Right. Well, thank you very much.
Thank you.
And instead of speaker gifts like coffee mugs this year, we're donating to the charity of choice of the speaker. And I'm going by memory, but I believe you chose Austin Pets Alive.
Austin Pets Alive.
All right, so we've made a donation in his honor from Kappa. So our spotlight member of the month is countyrecords.com. If you were at our all-day spring CLE, then you know that they sponsored a $500 grand prize, and I think that winner is even here today. She doesn't want you to know who she is because she's not loaning out money. Before I let him do his spiel, I'll tell you that I'm in probate, and we do a little bit of real estate, and so we're always looking for previous deeds. And if you go to the Travis County Clerk's office, there's some stuff there, but for some reason they don't have the older stuff as he does. So he has more information for me than the Travis County Clerk's office can even provide. And he also probably has cards. I have his cards if he doesn't, where he's giving everybody one free search. So if you don't even have to take my word for it, you can check it out and see if there's something you've been looking for that you haven't been able to find. So Roger and Bob, y'all want to come up and say something? Okay.
Yeah, thank you, Bob. Hey, we really are happy and proud to be sponsors and support